Good afternoon, everyone, and thank you for joining us today. We appreciate you taking the time to be a part of this important discussion on fraud prevention and business ethics in our industry. For those of you whom I may not have met or have had the pleasure of meeting, my name is Amy Holder, and I am the New Jersey State Manager for Security Title. I'm pleased to be joined today by our New Jersey Underwriting Counsel, someone I get to work with every day, Bill Slover. In today's environment, fraud schemes continue to evolve, making vigilance, sound underwriting practices, and strong ethical standards more important than ever. Our goal today is to provide practical insight, share real world perspectives, and help equip you with the tools needed to identify risks, protect your transactions, and continue serving your clients with integrity and professionalism. Security Title is grateful for your partnership and participation, and we look forward to a productive and informative session. Please allow me to introduce my friend and my colleague, Bill Slover. Hi, Bill.
Amy, how are you? Hello, everyone.
Hanging in. How about yourself?
The same.
Good. So let's get down to business here. What are we looking at?
Well, we are looking at a slide, uh, introduction to the core equation. So this is an ethics seminar, and ethics, obviously, in this context or in any other context, uh, is, is the question of proper behavior, the study of proper behavior. Um, Everybody's instinctive and intuitive understanding of what the word ethics means, something closely akin to morality, is a very good starting point. So hold on to that. And then if you move over to the next circle and you see standard of care, um, this is a phrase that is intended to alert all of you that uh, what constitutes ethical behavior in the title insurance business or in any other aspect of at least the business world that I can think of, requires uh, ethical behavior requires you at a minimum to understand what the standard of care for that industry is. Now, the phrase standard of care always sounds, as a standalone phrase, it always sounds like it could mean anything, anytime, anywhere to anybody who's thinking about it. But in practice, it means much more than that. The standard of care is defined in part by um, uh, the law in a given state, whether that's the substantive law of real estate or whether it has to do with the particular practices and behaviors of people and professionals involved in real estate in a given jurisdiction. And that also the phrase standard of care also implies, in addition to uh, the formal laws governing behavior in the title insurance industry, it also implies the practices that have arisen over the decades in our case in the title insurance industry, and those standards are um, uh, mostly written down, but certainly they're universally understood as being part of what is expected of you as a title agent. And when I say expected, of course, what I mean is, in addition to the expectation of regulators to obey the law, I mean the expectation of the insureds, the reasonable expectations of the insureds. And we will zero in on that phrase uh, very soon. So, in addition to the standard of care, we have a subcategory of that that has grabbed our attention over the last 5 or 10 years: fraud awareness, because the advances of technology have enabled certain kinds of fraud that can cost us dearly, both you as an agent and we as an underwriter. So when you take your own basic decency, basic understanding of right and wrong, and apply that to the standard, add to that the standard of care of the industry, which now it's right, it is proper, it is necessary for you to understand the standard of care and in addition to that, add in the latest piece of the puzzle, the fraud awareness. That should equal risk reduction, which results in the most desirable and ethical result of few claims. I mean, it is true that we're in the insurance business and we're supposed to um, write a check when there is a loss by our insured, but both our insureds and us, you as agents and we as underwriters, we would rather not be writing any checks at all, and so would our insureds. So and then at the bottom, uh, just to sort of look at this, what I've just said from the other end of the microscope, technology changes, but the ethical duty does not.
Okay. And that brings us to the Sears Mortgage versus Rose case, which I'm hoping that you can expand on a little bit and tell us how that relates to today's topic.
Sure, sure. As Amy said in the introduction, both she and I work for Security Title in New Jersey. Sears Mortgage against Rose is a New Jersey case, and so the precise holding of the case does not apply in any other state. And as a matter of fact, our chief title counsel and I occasionally, just when neither one of us has anything better to do, we kind of go round and round about how the Supreme Court of New Jersey messed up this decision, which it decided about 30 years ago now. The reason I bring it up as something that is appropriate to talk about in a seminar like this, when uh, a good 80% of you, anyway, probably more than that, are not writing in New Jersey, is because the reasoning of the court provides what I think is a good guideline for you to, in your daily activities, for you to keep in mind. Um, uh, I'm going to skip. I'm not going to skip the first two bullet points, but I'm going to jump ahead and go back. Look at the quote at the bottom of the third bullet point: the reasonable expectations of the insured. To me, that is like the headlight that a miner wears on his light. You, as title agents, deal with amateurs in a business that is technical, and large sums of money are being thrown around. And when something goes wrong, the amateur, at least in residential transactions, the purchaser is an amateur. Um, uh, you're in trouble if there's a dispute, and the amateur says to a court, or even to us, your underwriter, I thought. If the sentence begins, I thought, you're going to have a problem. What's going to come after that is, um, I thought that the agent was taking care of this, that, or the other. Now, it might not be reasonable for them to say, to have thought that. Um, some people still think the Mets are going to win the World Series this year. So it's pretty, it's reasonable is, again, one of those words that gets thrown around a lot, and it becomes a lot more precise once you get into the facts of the particular case. So let me get into the facts of Sears Mortgage against Rose. Rose owned a condominium in a middle class town called Leonia, which is, for any of you who care about this sort of thing, is up near the George Washington Bridge that crosses from northern New Jersey into the Bronx. Or I guess it's into Upper Manhattan. And it was a modestly priced um, condominium for its time. The contract purchaser, hired a lawyer uh, and gave his lawyer some money, that gave his lawyer the proceeds of the property that the buyer had just sold, and said, hang on to this for my closing. The lawyer said, fine. The purchaser went out and got a mortgage. Um, and so all the money was there at the closing table, and the lawyer then proceeded. The lawyer was a compulsive gambler, had a bad gambling habit, and he decided that he was simply going to, except for the net proceeds to the seller, which he obviously had to deliver right then and there at the closing, he wasn't going to pay off Sears Mortgage, who was holding the mortgage on the seller, and he was going to go down to Atlantic City, and he was going to turn that money that he had just stolen into a great fortune, then pay it off and live happily ever after. You'll be amazed to find out that it didn't work out that way. He went broke, he got caught, and long about that time, Sears Mortgage realized that the mortgage was in default. They foreclosed against Rose, the seller, who really had no stake in the matter anymore. Right? He had gotten his net proceeds and he was gone. However, the insured, I think Commonwealth Title, which was still independent in 1994, 1995, Commonwealth Title had issued the policy to to the purchaser and to the purchaser's lender, and so they were the ones who were on the hook. Now, Commonwealth, when this went to court, Commonwealth's defense was, hey, we insured this purchaser. This purchaser picked the lawyer. The lawyer was a crook. That's the cause of the loss. It was the purchaser's activity in choosing the crook that means that that was the cause of the loss, the proximate cause, and therefore that was an act of the insured under the policy. And we, Commonwealth, as unfortunate as it is for this purchaser, we are not obligated. The trial court disagreed with him. It went to the appellate division in New Jersey, the intermediate court, and the appellate division then reversed the decision, agreed with Commonwealth, and the purchaser then uh, uh, appealed to the Supreme Court of petitioned the Supreme Court of New Jersey. The Supreme Court of New Jersey took the case and reversed the appellate division. And the Supreme Court said this, look, it's true that this old common law principle about the person whose act caused the problem is the one who has to pay. But this is modern insurance law. We're going to not look at this as an old property case. This is modern insurance law. And in the world of insurance law, um, uh, the law of insurance has long been held to a higher standard in this sense that the insurance company has an unequally powerful bargaining position over the insured. And so these are what lawyers call contracts of adhesion. I don't know where that name comes from, but they will look at a contract. The idea is that an insurance contract will be looked at skeptically by a court to make sure that the insurer hasn't taken advantage of the fact that they have the much better bargaining position, right? Everybody has to get automobile insurance. And if there's some unreasonable provision on page 17 of your auto policy, a court's going to say, well, I think we might strike that down. So they went back to the reasonable expectations of the insured. And that's how the case came out. Commonwealth had to pay. To this day, if as I say, John Kosegoff thinks that's a terrible decision. I'm not so sure. I think it's all that terrible, but I always enjoy chatting about it with him. John and I are two lawyers who, among many others, suffer from um, uh, the problem of enjoying talking shop. So that's the case, and that's the reasoning of the case. And the reason I bring it up for all of you who are not New Jersey title agents is it would be a good thing if you looked at your practices and procedures and your employees and everything else about your business and said to yourself, well, in this area, what is the reasonable expectation of the insured? Remembering, of course, that many insureds are amateurs. Now, if it's some big developer and security, you get a claim from some big developer and you send it over to security title. we're we're not going to let them, at least not until the judge says so, we're not going to let them talk about the reasonable expectation of the insured as though this developer was, a first-time home buyer and had to scrape together $15,000 to get in the house. So, but the reasonable expectation of the insured, I suggest, is how you should evaluate your practices, your procedures, and most of all, your employee behaviors. Um, so that's that case. That's what it's about. If anybody wants has nothing better to do on Memorial Day weekend, send me an email and I'll be glad to send you the citation to the case. Uh, um, and I guess that's all I have to say about it.
Good information there, Bill. Let's talk a little bit more about what reasonable expectation means in practice.
Okay, again, let's drop to the punchline at the bottom. It's not whether you as owners of agencies, it's not whether you mean well. Unless there's real crooks in this audience, everybody means well. What you have to ask yourself is, are your actions resulting in a near zero risk on every transaction? Now, in one sense, that should be obvious because, as an actuarial matter, title insurance companies uh, get a very low payout in as compared to the underwriting risk, but that's because there are almost no claims, right? And so almost there's a lot of room between almost no claims and near zero risk. All right. So first, what are your, as an agent, what are your internal standards? What are the office procedures and documented safeguards? Um, uh, One thing's for sure, whatever your internal procedures and your documented safeguards are, have them in writing and make sure that every employee who is expected to know the office procedures or the part of the office procedures that are in the job description of that employee, that they know what the office procedures and the documented safeguards are. One thing you don't want, because it's not going to help you a bit, is for something to go wrong, a claim to come in, and it should fall on the, I don't know, the policy issuing department. And the person who's has the primary responsibility for converting a commitment to a policy post closing and checking to make sure that everything that's in is in and everything that's out is out, uh, uh, says in a deposition, I never knew that. My boss never told me about that. That's the last thing you want. And there's no excuse for that. There's no excuse for that. So make sure that your internal standards are clear. That is, they are not confusing and that they are communicated to your staff in a straightforward and simple way. And make sure that your documented safeguards are also in writing and followed every time. Again, in a court, if you're ever asked to testify, what you want to be able to say is, our safeguards are always followed. Okay, that has legal significance in the rules of evidence. Okay, not, oh yeah, most of the time, always followed, and you can prove it because you have them in writing. Okay, the agency agreement, one of my favorites. Strict compliance. That just shows you I don't have much of a life when I can talk about underwriter agency contract as being one of my favorites. Um, Strict compliance. On the other hand, you guys don't have much of a life either. You wouldn't be in this seminar a couple of days before Memorial Day. I'm kidding on that. Strict compliance with the underwriter requirements. Um, Read your agency agreement. I guarantee you there will be a few surprises in there, things that you thought you knew but you didn't. And the reason that the agency agreement is security title's way, and of course every other underwriter's way of saying, look, we're the company on the hook here. We're the ones with the policy liability, and you are authorized to issue our policies. And in addition to remitting premium promptly and keeping good records and all those sorts of things that agents have been required to do for as long as there's been a title insurance business. There are many other requirements now that are in that agreement. You're expected to know to a reasonable degree what the laws of real estate, what real estate laws that as applied to the title insurance industry are important in your industry. You're expected to know that even if you're not a lawyer. Um, you're expected to know uh, uh, what the what the requirements are to record a document, and you're expected to know when something changes in that area that you're on top of it. Um, uh, you are expected to know what the local custom of searchers is. If you're hiring your own searchers, um, the searchers you hire um, have to comply with the local standards. To take one example of that, and because every state is so different in its search, well, maybe not so different, but there are local practices that are different that vary from state to state because of the nature of the office that keeps the land records, the custom of the real estate industry that changes from time to time, and that's how the law develops. But to take one fairly simple example, um, in some states, uh, the rule is that when you're running a prior owner, or it could be the present owner too, but if you're running a prior owner, and let's say it's a developer, and there are 30 or 40 or maybe many more entries in the Grand Tour Index, um, how much of every one of those entries do you have to read before you can say, oh no, that belongs to a different property? In some states, in some states, let's suppose that you're talking about Pulte Homes, and uh, you're concerned with this particular subdivision, and it's lot 25, and you start pulling deeds, and it's about the time that this particular subdivision, Pulte Homes, completed it and sold out all 50 lots, or almost all the lots. And you're looking at those, and every time you get to the lot number and it's not lot 25, you stop reading and you check it off and you say, that's not me. In some states, if after lot 25 it says together with an easement across lot 17, um, you might have a problem even if Pulte Homes didn't put the easement in as a burden over lot 17. In most states, that's not true, but in some it is. So if you're in one of those states, then make sure your searchers are not just breezing through uh, uh, the deeds like that. All right, so that's the agency agreement, and then the near zero risk mindset. Um, Title insurance insures the past. Fraud losses can be prevented with heightened care. Um, I'll give Amy a chance to. Do you want to hop here with the kind of fraud losses that you run across in your daily practice, Amy?
Sure. I mean, I think we're going to get to that a little bit later in one of the other screens, Bill,
Okay. All right.
just because I don't want to repeat it too many times. I think we have a couple of examples as we go on of what fraud losses look like today, or different fraud practices look like today.
All right. Well, then yeah, perfect. So then we'll end this slide just by saying, go back to the phrase in quotes, reasonable expectations. I suggest to all of you that if you review your procedures, looking at it from the view of the insured, especially an amateur, a homeowner, um, ask yourself what that person's reasonable expectations are, and are you meeting them? And that's a good place to start, and make sure you're not missing some particular practice or procedure that you really should be implementing. All right. Oh, okay. Uh, so yes, let's you all know this, but let's nail this one down. Agent responsibilities. Closings are the agent's sole responsibility. Now, um, as you know, the agency agreement says that closings are are the agent's sole responsibility. So if a claim comes in and it has to do with the the agent's uh, activities at the closing, the underwriter is going to say, no, closings are outside the agency agreement. They are beyond the authority of the title, beyond the authority of you as a title agent to act on our behalf. And therefore, we, the underwriter, don't have to pay this claim. Now, I'm not suggesting that every time a title underwriter said that in a court of law, the judge banged down the gavel and said, oh, you're absolutely right. I mean, there's a lot of wiggle room, gray area, whatever you want to call it here. But it does mean that the courts have recognized that to a large extent, the agents, the agency agreement, that is the agent's authority to act on behalf of the underwriter, and here's a key word from the law of agency, bind, B-I-N-D. When you issue a policy and the policy says that a survey by so and so, dated so and so, shows clear, or however you phrase it in your state, that is an action that you are taking in your under your authority as the agent to issue a policy. Okay, and if your misreading of that survey, if you said it shows clear when really it showed Amtrak's Northeast Corridor line running right down the middle of the property, unfortunately, security title, that is a covered claim. Of course, security title or any other underwriter will then say, well, you were negligent in your duty because anybody who wasn't blind should have seen that Amtrak had an 80-foot wide right of way running right down the middle of your property, and therefore we can recoup our loss from you. But the legal point here is that you were within your authority to read that survey and incorporate it into the policy, right? Compare that with your job as when you do a closing and you make a business decision that you're not going to have employee closers, you're going to employ an outside closing service, of which there are many, many, many now because of the change in the way things were done since COVID. If that um, closing service uh, goes to a closing and improperly accepts a discharge of a mortgage, a private mortgage at the closing without contacting you or insisting on what would be considered under local practice, uh, uh, taking the reasonable steps to make sure that the signatures on the discharge are, excuse me, are genuine and that they are the people who to whom the money is owed, that's going to be your problem because that that closing service was acting as your agent in the business of conducting a closing. Okay. Now, again, it's true that the underwriter may have to pay because some mortgage company didn't get paid off, but they certainly are going to come after you because the decision that caused the loss was your decision to hire a a um, uh, a settlement service that was not up to the standard of care of the industry. Okay, all right. So there's that. That's the distinction there. So what you were doing as a closing agent, you're on your own, and of course that's why you have to have E&O coverage, and we insist upon it for exactly this reason. And so do your other underwriters, of course. Amy, I guess we're going to talk about um, uh, some of the some of the problems with E&O coverage at a later time? Or is this as good a time as any to bring that up? I was just thinking of cybersecurity riders.
Bring it up.
Well, okay, I mean, there's not much to say.
Well, I mean, the important thing to note there is that not you really have to read your E&O policy, just like you need to read your agency agreement and make sure that your E&O policy covers the scenarios that you're looking to have covered. Most E&O policies don't cover cyber theft or cyber security. So you may have to get an additional cybersecurity or cyber theft policy or a rider to your E&O policy. But the important thing is to know what your E&O policy covers. Don't don't just assume because you're getting $1 million E&O policy that it's going to cover every scenario, especially when it comes to fraud and cyber theft.
Yeah, yeah, we've had agents here in New Jersey who have been very surprised when they realized that they didn't have coverage, and there's no reason to think New Jersey's any different from any place else. So,
Correct.
yeah, yeah, okay.
Correct.
Um,
I had a conversation last week with a new agent who's setting up an agency for the first time, and he asked me, should he get a cyber policy? And my answer to that is, if I was a title agent today, knowing what I know and seeing what's in the news, I would never allow myself to be exposed that way. So, I can't make the decision for the agent, but I can certainly let the agent know how I would behave if it was my agency.
right, and of course the tide to ethics here is that you need to behave. It's not just that the cybersecurity rider to your E&O policy makes business sense, although it does. It's that it's that you have an obligation to the people that are being insured, and you know that the theft of closing proceeds is something that uh, the underwriter is going to say that they're going to deny coverage on the grounds that it was your uh, closing activities that in which the loss occurred, and that you should not leave yourself exposed that way if for no other reason um, uh, the person who suffers the loss, assuming they weren't the fraudster, the person who suffered the loss has a reasonable expectation that somewhere along the line, some insurance company is going to write a check. And if it's a closing matter to review here, that's going to be in all likelihood, your E&O carrier and not your title underwriter. Okay. All right. I think we're good
Okay.
there, Amy. Yeah.
All right. Oops. Sorry, I'm having a hard time with my mouse. Okay. All right. So here we're going to talk about how the standard of care evolves. Um, Considering that the closing may happen in an agent's office, but the liability can travel. If we think back to the way we behaved as agents 15 and 20 years ago, it wasn't really necessary at that time to verify a wire change. If there was an issue, it probably wouldn't have been considered negligence simply because it was not common practice to verify that change. In addition to that, you have a duty to verify a person's identity. And a lot of times that we would use driver's licenses. 15 to 20 years ago, we would take a driver's license, look at the picture, look at the person, and be satisfied with that. When we look at how behavior has changed and how fraud has taken place today, if you receive a change wire instructions, then you have a duty to verify those wire instructions. And by verifying, it's not calling the phone number or emailing the email address on the letter or the email or the notice of the change. The best practice would be to go to the public facing website for that institution and get a phone number off of the website and call and verify. If you fail to do that today and there's a theft of funds, it's more than likely that that's going to be considered negligence on part of the agent, simply because the standard of care today is to verify those changes. Um, and if we talk about a casual inspection of a driver's license, we recently had a situation in New Jersey where um, a person presented the driver's license, and the agent or the employee of the agency actually looked at the driver's license and accepted it as a proof of identity. The problem was that it was fraudulent, and the way that it was fraudulent is that the birth date, though the birth date was correct for the rightful owner of the property, 1954, the picture on the driver's license represented a 30-year-old individual. So it becomes almost a private investigator type process where it's not simply looking at the photo and looking at the person in front of you, but you need to actually read the driver's license, look at the birth date, determine if that birth date matches the picture. And it's true that not all states may change the photo every year, but I think that it is common sense and logic that it's not that there isn't a state in the United States that's going to allow a person to use a 30-year-old photograph on a driver's license. So as we think about how the criminal tactics evolve, then the standard of care moves with them. Criminals are working 24 hours a day to steal your money, and steal the money of your clients. And I feel personally as if every day there's a new scam that we have to learn about and read about and become accustomed with. And and we do, because they're working really, really hard finding new ways to take things that don't belong to them. So we have as an industry, we have a responsibility to have that standard continue to evolve to keep up with the thieves or the bad actors. I won't say thieves. Sorry.
Amy, are we on schedule here? It's already
I think
20.
we're running a little behind. So we can just, if we want to just pick up this next slide here, and we can go to our poll question, and I'm going to skip some of the other things that we had written out on notes here, but
Okay.
we're good.
All right.
Um,
So if we do get a chance, I want to come back to another example about the evolution of the standard of care. But moving on, um, let's be quick about this. um, so uh, let's talk about true title risk, because these are the sorts of things that um, that an underwriter, if an underwriter gets a claim of certain types, the, the underwriting counsel, somebody like myself says, you know what, you can't hang that one on the agent. That's just life. I was an agent for many years, and the only claim that ever came up was one that, in order to resolve the claim, the title had to be searched back to 1847, and and the doctrine of paramount title had to be applied. And sure enough, the the common owner back in 1847 conveyed out the other property, and then conveyed the insured property, including the overlap. And of course, by that time, the common owner didn't own the overlap because he'd already sold it. So the underwriter had to pay. And I was very grateful for underwriting counsel at that time to call me up, and as the case was resolved, he said, Bill, we know that nobody's going to search a title back to 1847, so don't worry about it. It also helped that it was just farmland. I think if it had been, the southerly half of the Empire State Building or something, it might not have been such a pleasant call. But anyway, so there's that. Unknown liens. Um, Again, those things vary state to state. Errors in the public records. The misindexed instrument again is something that almost never can be laid at the feet of a searcher or an agent. You can't. If something's misindexed, you can't find it. The index is part of the records. In most states, there's a case dead on point on that. You can't search a title if you can't rely on the index. Missing or undisclosed owners. This is getting close to the fraud or the forgery again. Um, what would we say here? Um, I'm thinking of sometimes the application of the estate rules to transfer property can be a little bit confusing. Sometimes all the proper documents don't make it into the estate file. Um, you know, just be careful when you're dealing with a dead person or the dead person's estate. I know, I know. How can you deal with a dead person? Good question. All right.
You were reading my mind, so.
Let's see, preventable fraud law, losses tied to verification failures. Well, Amy just talked about that. Fund handling. I started to say the oldest scam. Well, it's not old; it's new. But the one that started all this was the person who just jumped in and invaded somebody, took over somebody's email and sent them a false payoff letter. So whatever you do, don't let that, don't do what would allow a fraudster to do that. That's a pretty easy fix these days. Um, Ignored red flags. Well, Amy, you want to say something there?
Yeah, I mean, we're talking about preventable fraud losses. So I think that um, if you look at ignored red flags, every transaction, when you're handling each transaction, if you see a red flag and you choose to ignore it, then that is a substandard standard of care. If you have a situation, let's say, where you have a seller who happens to be out of the country and you can't verify who that seller is, that it is the appropriate person to be selling that property, or you have a real estate agent who's never met the seller, or you have a situation where the seller is needing a fast closing with a cash transaction, and that it's selling for below market price. All of those things are red flags that should cause an agent to stop, take a breath, look at the situation and say, something doesn't smell right, something doesn't feel right. Let me ask a question. Let me contact the realtor. Let me contact the attorney if you're working in an attorney state, and start asking questions. There's nothing wrong with asking questions. It doesn't cost you anything but time, but it can save you in the long run a whole lot of money.
I'm in, on this theme of ignored red flags. I'm an expert witness in a matter right now in which another underwriter, through an agent, insured an oceanfront property, and the survey, which wasn't delivered until the closing, showed a wooden walkway that ran across the sand. This is beachfront property, and the walkway was at one corner of the property, and it started at one end at the west end of the property and extended across the whole 120-foot length of the property and stopped at the east end, which was the public beach. And the agent who was there at the closing, didn't say to somebody, well, what the heck is that? Since there was no recorded easement, and now of course there's this big litigation about, between the owner of the $3 million oceanfront property and the owner of the property behind it that's worth $1.8 million. who says anybody should have looked at that survey. Who do you think used that walkway? Me. And I can tell you that the underwriter for the who insured the oceanfront property is not too happy with their agent. So there you go.
And that's not a security title. The security title is not the underwriter in that case. I
No,
just want to make clear.
no,
Okay.
no, it's not. If it were, couldn't very well be an expert
Okay,
witness
I
for
just wanted to
side
be
or the
clear.
other.
I just wanted
That's
to be
right. Very good, Amy. All right.
clear. Okay. So if we look at a true title risk example, a 10% risk of a $1,000 claim may be unacceptable, while a 50% risk of a $1,000 claim may be acceptable. That's coming right from the New Jersey Title Practice Handbook. And it goes again based on the care that the agent has taken. If this is something that you couldn't have avoided, if it had something to do with, unknown liens or errors in public record, that may be much more acceptable than if you chose to ignore a red flag or you didn't verify a change in wiring instructions. Um, so just keep those things in mind. And I don't know, Bill, do you have anything off the top of your head for an example of a preventable fraud loss, that may be a recent one, maybe the one in Morris County? Because that would have been preventable.
Okay, sure. Yeah, we can talk about that. Um, this was vacant land. We were asked to insure, one of our agents was asked to insure vacant land, a small lot of probably just suitable for one single family detached home. And the purchase price was relatively small. And the instructions from the sellers, so-called sellers, was to get this. It was a husband and wife, and 50% of the proceeds were supposed to go to a bank in Vietnam, and the other 50% were supposed to go to a bank in either Canada or England, I forget,
Canada.
and,
Canada.
and Canada, and the spouse, one spouse, the signature of the spouse on the deed was supposedly notarized at I forget whether it was the embassy or maybe a consulate in Vietnam. Nobody had shown up at the closing. The notaries on the deed were both notaries in those countries. And so neither the seller's attorney nor the realtor had ever met these sellers. And our agent just kind of said, well, no harm, no foul. And we're not too happy about that one either, because we think reasonably, in our opinion, that those were sufficient red flags that if the agent if the agent had asked a few questions and found out that nobody had ever seen either of these people, and then tried to compare it uh, to the property address where the tax bills were sent, right? Because this was vacant land. The owners lived in Texas, so now a property that was being
The
insured, vacant
rightful, the
land.
rightful owners, the rightful owners lived in Texas.
Yeah, the rightful owners lived in Texas, and that was easily discoverable off the tax search. So,
Right.
um,
And
uh,
interesting too, in that particular situation was that the sellers were represented by an attorney. So the agent was communicating with the attorney, and the attorney had never met the seller. And so the agent was relying on both the attorney and the real estate agent to have done their due diligence to vet that this was the rightful seller. So by the time it got to the agent, they thought that all of this was valid. And indeed, it was not.
we're,
Yeah,
we're yeah, we're lucky in the sense that the claim is relatively small, but
right.
that doesn't
But it's
make us
still the
any.
same.
That doesn't redound to the credit of the agent.
Right, right. So now we're going to pay a little bit of attention here to common fraud in real estate transactions and focus on the categories most likely to create risk for title agents. So, Bill, do you want to talk a little bit about the identity and ownership fraud?
Uh, yeah, this is a real problem. I mean, the reason it's a real problem is because it's difficult to detect. I mean, when we talk about ownership fraud, we're talking about forgery, basically. Somebody just comes out of the blue and claims to be the true owner or the lawful uh, 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 minority owner, say, of a business who has full authority to sign any document. And because it's such an easy thing to do, that is forge a deed. All you got to do is slip a crooked notary a few $100s, or buy a stamp from a crooked notary. It's such an easy thing to do, and there's such a high reward. Um, I don't know what I can say other than what's already been said in order to uh, watch out for this one. And I also will tell you that at least in New Jersey, the district attorneys um, have no interest in prosecuting these cases. One of my best friends is a lawyer, has been doing mortgage foreclosures for decades, and his company, his foreclosing lender, found out about this, that their mortgage had been fraudulently discharged, and they didn't get paid, and the property was sold, and the crook, the owner slash mortgagor, walked away with $400,000 that he wasn't entitled to, and was living one county over. And my friend went into the prosecutor's office and said to somebody, "Hey, this is what happened. Here's where the guy lives," and they weren't even interested in prosecuting him. A $400,000 theft, just plain as day, and he didn't even get he barely got the time of day to hear him stop. Oh, you're a big bank. What's your problem? Kind of thing. So this
You know what
stuff
I'll add
happens.
to that too, Bill, is that if you are a title agent and have a notary in your office with a stamp, um, it's a good practice to make sure that that stamp is under lock and key when not in use. We had a case many years ago where we had a high traffic agency. They had a lot of people coming in and out. They had a close. Someone had attended the closing and saw where the notary had kept her stamp in her top drawer in her desk without a lock. He came back a week later, purportedly to do some type of business. And when the time was right, he stole the notary stamp.
Oh yeah, I
So
forgot
if
about that.
you
Yeah.
Yeah. So if you have a notary or you have a um a stamp in your office and you have a high traffic office, make sure it's under lock and key when it's not being used because he stole the notary and then he stole somebody's property and took out a mortgage. And actually, Bill, now that I think about it, in that case as well, they chose not to prosecute. The state chose not to prosecute. It was a $350,000 mortgage. It wasn't enough money and the guy got away with it.
Yeah, there you go. There you go. I would like to, Amy, I know we don't have a lot of time left.
Yeah,
I
yeah,
would
yeah.
like, I would like to go through the fact pattern of a slightly more sophisticated uh, fraud, but it's up to you. I don't know how you want to manage the time.
Go ahead. No, go, 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 go.
All right, all right, everybody. This is kind of the going. This is sort of the hot crime up here in the New York, New Jersey area, and five or six underwriters, including Security Title, are involved in trying to get money back. It looks like we're going to get some money back because one of the crooks finally got indicted by the U.S. Attorney's Office in Manhattan, and then lo and behold, he decided to start talking. Imagine that, one night in jail, and things that'll change somebody's outlook. Anyway, here's how this goes. Uh, Somebody who has allegedly no connection to a piece of property goes on the New Jersey State business website and changes the name and address and email and contact info for the registered agent of an LLC or a corporation. Then, and that can be done in 90 seconds. Then the registered agent, now the new fraudulent registered agent, goes in and adds a new owner name to the entity. And now with this new fraudulent owner name, the entity goes and borrows money from a private mortgagee, a hard money lender, and the new mortgage, and then they go get title insurance, and the fraudulent owner, who now can be verified on the state website, now signs the mortgage, and let's say the mortgage is for 700,000. These are real numbers, for 700,000, and they pay off the existing loan of three, and now there's $400,000 for the scammer to walk away with. And then, of course, the owner, the true owner, doesn't know that the old mortgage has been paid off and that there's a new $700,000 mortgage that he doesn't pay, and the new $700,000 lender forecloses, and then the true owner claims on the title policy saying that the this is a fraudulent mortgage. I didn't sign that, and that person didn't have any authority to sign. So title company pay up. And now, for those of you who aren't paying attention, here's the punchline: the true owner, the fraudster fake guy who supposedly was an authorized signatory, and the lender are now splitting the $400,000 three ways, because the title company is going to have to pay. This particular pattern has been repeated about 20 times in New York and New Jersey. And finally, underwriting counsel for many underwriters got together and figured out it was, 40 different entities, but it was all the same gang. So, if it can happen up here, it can happen where you are. I don't have, I don't have a foolproof way for you to detect this either. I just don't know. It's just the forged identity.
Yeah. Real quick, I think that I'm just going to read through this real quick, Bill, just so that because we're up against the clock at this point.
Yeah.
But understanding some current scam and tactics and tools. The tools vary, but the pattern is familiar. False confidence, urgency, and misdirection. Anytime you get typically involved in a situation like this, there's a lot of, we've got to do this now. You get an email saying this has to close tomorrow. And that should be a red flag as well, right? Um, I wanted to, like, that wasn't the screen I wanted though. So I guess so just some practical risk reduction practices to help um, manage the risk in each situation. And these are core practices that every agent should implement using unique 16 character passwords. I read something interesting from a report that somebody sent me this morning that 16 character passwords that contain numbers only could take about 2,000 years to crack. But a 16 character password containing numbers, letters, both uppercase and lowercase, and symbols will take about 94 quadrillion years to crack. So obviously, the more difficult we make the passwords, the more difficult it will be for a bad actor to come in. Requiring MFA on every account. MFA makes accounts 99% less likely to be hacked. Limit administrator privileges. That's pretty obvious. Hover over links before clicking. Phishing and spoofing was the number one IC3 crime type by complaint count in 2025, with 191,561 complaints in 1 year and $215.8 million in reported losses. So when you get an email that says, here's your new employee handbook, and click this link, you want to make sure you're hovering over that link and validating that it is a proper link before you click it. By clicking it, you could easily let somebody into your system if that's how they've chosen to come in. Compromised email accounts, independently verify email authenticity. We talked about that earlier. Look at a public facing website, get the number, make a phone call. Calling to confirm wire instructions, same thing. Make sure that when you have a valid patch, you're patching your systems. The patches help keep your system secure and prevent others that shouldn't be in your system from coming in. Educate all your employees, everybody, anybody that's working on your systems in your office should be aware of of how to behave and what to do in terms of um, email and the potential to be compromised. Test incident response and backups. Again, according to the same report, which was the small to medium business cybersecurity report, only 34% of small to medium business owners have a formal incident response or business continuity plan developed with a cybersecurity professional. The report also found that 80% of small to medium businesses with a formal plan avoided major damage during an attack. So even though it may seem like a big lift, talk to your IT person, talk to people within the cybersecurity industry, and develop a plan that will best protect you and your business. If something feels wrong, pause and call. So if something doesn't feel right, it doesn't look right, call call your agency rep, call your underwriting counsel, call your software folks, call your IT guy, call your friendly agent neighbor and say, "Hey, does this sound right to you?" If it doesn't feel right, trust your gut. Your gut's important. Bill, you can take this last. I think this is it. This is where we'll wrap up.
All
What
right.
short probably expects today.
Yeah. So we talked about strong cybersecurity. We've talked about careful disbursement, and we've talked about paying attention all the time. So fraud prevention is not optional. Uh, Ethical behavior requires that you um, live up to the modern standard of care, starting with you have to know what it is. And certainly part of the modern standard of care is the strong cybersecurity. So these are not difficult or vague concepts. All of you know what you have to do. Um, and the trick is to just make sure that you're doing it every day in every situation.
Very good. Drew, do we have any questions before we wrap up?
We don't have any questions yet. If you need something answered, please submit them now. Thanks.
Anybody has any questions, feel free to drop them in the box while we take a few minutes. Again, a final thought, pause, verify, document, escalate. The number one thing that fraudsters want us to do is panic, right? We don't want to lose the deal. We got to get it to close. It's got to close in the next 3 days. Take a breath and just pause and make sure that you're not spotting any red flags, that you're doing everything you can in your standard of care to meet the expectations of your clients and protecting not only yourself, but your underwriter and your employees, yourself, and your underwriter. We good, Drew?
Uh, Unless you want me to hang on for a minute or two to see if we get any questions. We don't have any yet. Otherwise, maybe direct questions to you or Bill or the security title
Sure.
legal team.
Yeah, sure.
Sure. Let's do that. So if you do have any questions or you'd like to have a follow-up conversation, I can be reached at aholder@esecuritytitle.com. And Bill's email address is bslover@esecuritytitle.com. I hesitated because Bill always jokes and says, if you need to remember my email address, remember bslover@esecuritytitle.com. And I almost said that, even though I just said it now. But it's bslover@esecuritytitle.com.
You,
And thank you, everybody, for attending.
you see the abuse I have to take in this business. Right?
But thank you, everybody, for attending today's webinar. And we look forward to seeing you again real soon. Have a great day.